I would like to thank the management of the Radical New Bar for this opportunity and to share my insights on a number of issues, also on the digital number plates, more specifically now known through the ITMS or EPS regulations. Firstly, I thank the President of the Radical New Bar, President Isaac Semakadde, for exercising vigilance on the Intelligent Transport Monitoring System, or ITMS, which posed monumental risks whose harmful effects that the greater public has just realized when the injustice has finally come to their cars and wallets. This scandalous project started actually in the COVID-19 pandemic. At this point, I want to emphasize that there is a link between the ITMS and the EPS, because the ITMS is a technology driving the EPS system. Well, from the onset, it is more evident that this is a predatory system, and its main intention or objective is to raise revenue for those that are really behind it. And I want to state that as early as July actually 2021, President Isaac Semakadde had already started banging the table, because at this point only few people know that a number of people who can barely go beyond this room had hatched a plan to extract up to $1 billion from Ugandan taxpayers through the non-tax revenue. This system, as you may recall, was launched by the Ministry of Works and that of Security. And I want to state the interventions that we have since done from the time we realized about this predatory system. For example, from the onset, there were about 2 Ugandan companies that were in the business of manufacturing number plates. I think there is GM, Tumpeco, I forget the other one. As we speak, those 2 companies are out of business. I think one was sent to operate in Sudan. I understand it might have had people that it employs. Contracts were cancelled, and I believe, as you've seen from the astronomical finds from this system, it's a system that was never intended about the safety of the people, but rather to benefit only a cabal of people, whom we already know, by the way, as early as 2021. We want to start with the first intervention that we took. Number 1, the High Court Civil Division, by around 2021, certified that the matter of stopping the intelligent transport system was very urgent. You may recall at that point, even advocates were considered non-essential, but court certified that miscellaneous cause number 225 of 2021 was very, very urgent. In this case, the applicant is Legal Brains Trust, who duly instructed our firm, GEM Advocates, to file a Human Rights Enforcement Act motion seeking a declaration that the presidential directives, cabinet resolutions, advice or approval by the Attorney General, contracts, statutory instruments, or other documents by whatever name called, through which the government of Uganda had purportedly engaged a Russian company called the Joint Stock Company, Global Security, or any other person or authority to execute a program of digital surveillance of all motor vehicles, motorcycles, and other vessels. This can also include boats in Uganda, that this violated a bundle of rights and protected freedoms. It is important to note that some of these violations are not yet known to the public. For example, the ITMS violates in its present form. I'm also mindful of the sub judice rule. Since this is an ongoing case, I'm only restricted to stating what is already in court. For example, the system violates Article 21.1 on equality of all persons, Article 24, which is on respect for human dignity and protection from inhuman or degrading treatment. For example, under this new system, you may not know, but you will have to be surveyed for 24 hours. There is an infringement or a threatened infringement on the right to privacy, home, or property. We've maintained that the government has no business following us around. You can't follow everyone, everywhere. For example, there is a cyber stalking law that prohibits people from being stalked. You can't follow people from the streets everywhere they go. For example, why would you otherwise track persons that have no linkage to crime or terrorism? There are civic rights that are being breached, but most importantly, the government, by engaging the Russian company, created a monopoly. This is not the first time it is happening. Sometime in 2000, when you look at the case of Spedag Interfreight Uganda versus the Attorney General, a certain family linked to the first family created a company which was given rights to have exclusive rights over the port, the purported port in Tororo, and by giving this one company rights, it took companies like Spedag to fight this monopoly. So you may recall that all Ugandan companies that were in the business of manufacturing number plates have since been laid off in favor of a Russian company. I think this case that I've just given highlights the importance of courts in curbing creation of monopolies. And then there are a number of other rights. And then who actually stores this data? You've seen over the past weeks that pictures of cars are being shared. Now, how do you guarantee that, one, this information is stored, and any other person that might otherwise be trading you won't have access to this information? Secondly, there are data protection concerns. We don't know who the data protection officer is in terms of the Russian company. Now, pending determination of this main cause, the human rights enforcement application, we filed a temporary injunction application in July 2021. It took the High Court. You know, the anger of the people has been directed to the wrong people. We, at this point, accuse the judiciary of Uganda. It took the judiciary a total number of 539 days to deliver a simple ruling on an injunction. Had we succeeded with the injunction, perhaps the EPS, which is founded on the ITMS system, wouldn't have seen the light of the day. Upon receiving this ruling, which obviously dismissed the application for a temporary injunction, We then applied to the Court of Appeal and successfully had our case fixed before a single justice of the Court of Appeal. I don't know if we're lucky or unlucky, but we landed on the Honorable Justice Oscar Chihika, who, unlike the initial judge, who didn't find any grounds of a temporary injunction. The lawyers know you must have a prima facie case, you must have a status quo to preserve balance of convenience. The judge agreed with us that at least we satisfied close to 3 grounds, but only didn't satisfy the one of balance of convenience, because the government was then in a rush to implement this program. So we've so far accused one entity or one institution, which is the judiciary. Now, pending the second ruling now of the Court of Appeal, initially this program had skipped even Parliament. But now they worked backwards and dealt with a number of MPs who sat in a committee and green-lighted approval of this project. It only took a few reasonable MPs who saw what you've been able to see in the past days. For example, concerning the sharing of this money, and our government negotiated a very bad deal. More money goes back to the Russian company with over 80%. You can question whether all this money is indeed going to the Russian company or it has a number of other beneficiaries that are not listed or known anywhere. We then take issue with the exercise of the functions of Parliament that didn't exercise caution in trying to stop a project which would ultimately affect the general public. So this pseudo-parliamentary approval only created harm. We've also been made to understand that the major reason why this program is being fronted is because of crime. Incidentally, to those of you who pay close attention, at the time they were launching this program, they were murdering women in Entebbe. None of these suspected murders were using cars. So you can't get the empirical evidence of stopping crime and this system that they greatly want to impose on the people. And I think from that, everything about the Russian company, its financial capacity, its financial model, pending the temporary injunction, we also filed an application for discovery. For example, everything surrounding this project has been a mystery, from the contract that government signed to the feasibility model to the sharing agreement. All these agreements have been kept from the public. I want to remind you and emphasize that every Ugandan has a right to participate in the affairs of government, whether directly or through their individual representatives. Secondly, Uganda is a member of different blocs in the region. For example, the EOC, EAC, and also the COMESA. Now, if the intention was to stop crime with cars used within Uganda, what then happens to vehicles that have free access to exit and enter Uganda that are coming from Kenya or from the COMESA? Why are you not? It would have been more prudent that this is a project that goes across maybe the entire EAC block or the COMESA, and then we have a number of concerns. Number one, as we speak, the last time we appeared before the Court of Appeal was in 2023. We had to make a reference where you're dissatisfied with the decision of a single justice. You then apply to a full panel of 3 justices to review any decision of a single justice. For over 3 years, from the time we filed the motion and close now to 2 years. The Court of Appeal has never found the urgency to fix that reference for hearing. We note with concern then that the judges have eroded the judiciary as a forum for checks and balances. It was at this time that the judiciary ought to have done what Parliament didn't see and what the executive is vehemently pushing down to execute. And then this will leave Ugandans with no any other option save for maybe civil disobedience. We have seen that as of yesterday, they have again attempted to hoodwink Ugandans by suspending the EPS system without suspending the ITMS, because the EPS system, when you look at regulation 3.2 of the regulations, it clearly states that it is being implemented on the basis of the ITMS system. So without stopping or dropping the ITMS system, by suspending this EPS system that is clearly hoodwinking Ugandans, we emphasize and urge all that are involved to completely drop this system. There are other alternative systems which are less intrusive. For example, Professor Isaac mentioned something to do with the automatic number plate reader system. All you need is a working camera and then maybe other technology which can detect the movement of cars, and you issue receipts. If you find it more prudent, why then do you have to place a gadget on a motor vehicle to track a car without limit? And then I want to briefly talk about the regulations. One, the regulations are in themselves illegal from the onset because they are founded on an illegal and illegitimate system which is being challenged in courts. A number of people have already mentioned, but to mention but a few, the system doesn't respect the due process. Back then, Nafande has mentioned that the person had to pay these fines within a period of 28 days. Why the rush now? So for the explanation that maybe money has to be collected and shared, that you have to force someone to pay the penalty within 3 days. I think in conclusion, we urge the following stakeholders to act accordingly. We call upon the judiciary to expeditiously file, rather fix the reference to the entire court, to the full panel for hearing. We urge government to immediately drop the ITMS system, suspending the EPS system, whose empirical evidence is not even existing, is not sufficient. And we call upon activists to always show up but not show off. This is an issue that has been around this country for close to 4 years, from 2021. And to lawyers to be more vigilant. It is shocking that some of the lawyers or some of us only saw the regulations after they had started implementing them. We only start to comment as ordinary citizens. We call upon everyone to be most alert in terms of fighting such policies. I thank you.